of the people cannot be respected, cannot be upheld where there is serious transgression at the wishes of the chairman of the Electoral Commission. Finally, my ladies, my lords, there needs to be a retribution. There needs to be a stop of all these transgressions. How many times shall we subject Kenyans to these processes? How many times should we appear before you with the same grievance every day, after every elections? There ought to be a stop. And a stop is making sure that the proper sanctions, criminal sanctions, as prescribed by the Election Act, are meted against any transgressor. And there is no one who is above the law, including the chairman, so that people may learn to respect the law. I'm so obliged. I donate the 26 minutes to the court.
Thank you.
Seconds.
Those are seconds. Thank you very much, Council. Regards petition number 7, we have Mr. Omtata appearing for himself, and Professor is appearing for the other. So I think you'll share the time, Prof.
Yes, thank you, Your Ladyship. Well, our submissions will be in two parts. The first part will be qualitative, and I will address myself to the law and complement the submissions that have been made by learned friend, Senior Counsel James Orengo, learned friend, Senior Counsel Philip Murgor and Feroz Noroji, on the questions of compliance with the law and on the unconstitutional nature and the non-compliant nature that the first respondent, Mr. Chebukati, employed in running the presidential election of 9th August 2022. My lords, the person I do not want to be now is Professor Githu Muigai, because every single advocate in this court has spoken to the violations by his client. Violations, my lords, that border on the violation and speak to the violation of Article 3.2, the unconstitutional proceedings that led to the issuance of Gazette Notice 9773 of 2022, issued on 16th August 2022, that declared the president-elect. My lords, we shall be asking that that violation or that Gazette Notice be vacated as we make several orders, my lords, under Section 84 of the Elections Act and Article 143 of the Constitution. My lords and my ladies, let me start by submitting that my submission shall be around one, the issues framed by the court, particularly, my lords, issue number 8 on illegalities and irregularities that, if applied disjunctively as this court has ordained before, my lords, will lead to a compelling order of nullification of the elections of 9th of August 2022. But I will also, my lords, and in view of the powers of this court under Section 3 of the Supreme Court Act, delve into the interpretation of Article 143. And my lord, perhaps because this court is also the jurisprudential head of the judiciary, to see, my lords, whether there are possible sanctions or possible findings that this court can make other than the order of nullification. And my lord, that will be in my last submission. My lord, let me just touch on the second part. The second part that my learned friend Mr. Omtata will deal with will be the maths, electoral maths, the mathematics of the election. We will demonstrate by way of a PowerPoint presentation that none of the candidates met the 50% plus one vote as per the tallies that were read by Chairman Chebukati on the percentages, weighed against the voter turnout and the votes cast, my lords. And that will show that if indeed no candidate attained the 50% plus one, then this court has a daunting task. One, of course, after the exercise that is ongoing, the exercise that is going on with the server, my lords, we will be asking this court, my lord, to think of the possibility of declaring a winner after the outcome of the access to the back end of the server. That's number one. But number two, my lords, patently, the results announced by the chairman of the IEBC were unconstitutional because they did not emerge from the commission. And granted, my lord, that they were unconstitutional, if the court then is unable to arrive at a result as to who won the election, my lord, then of necessity the court would then would have no option but to proceed to nullify or find that it was conducted illegally. My lord, let me just proceed because of time to the key submissions. My lord, it is patent and glaring that there was non-compliance with Article 81A and D of the Constitution, read together with Article 86E of the Constitution. The elections were not verifiable inasmuch as voting took place. The process of tallying of the presidential vote from the polling station and the issuance of Forms 34As transmitted to the constituency tallying center and finally to the national tallying center, my lords, was not a verifiable process. My learned friend Philip Murgod has spoken largely to the access that two individuals had to the system. He had spoken of one Dahir and one Kwanusu, who had access over 1,000 times Mr. Kwanusu, the PA to the chairman, Mr. Professor Githu's client. Clearly, my lords,
I would like to request the Honorable Court that we conduct this petition in the tradition, in the very long honored tradition of each counsel arguing his case without any sideshow.
my lord, it is a fact that the chairman is Professor Githu's client, but I will, because of the discomfort, address myself to
yes, I'm speaking.
Yes, my lord.
I think you should treat your colleagues with respect. We all know that who is representing who. So make your point.
My lords, I will proceed. I will proceed. I will not mention Prof's name going forth. But my lords, the violation is glaring in view, my lord, of the fact that the non-verifiability of the process from the tallying center as held by the Court of Appeal, my lord, we've spoken to this severally, to the National Tallying Center of what each presidential candidate received, my lord, is a subject of an unconstitutional act. My lord, that is point number one. My lord, therefore, the counting, there was a violation of the duty to count each vote cast by an individual as contained in the Form 34A transmitted to the National Tallying Center and as uploaded to the Form 34Bs and 34C that was used to declare the result in Form 34D, my lords. My lords, granted further, that violation is also reflected, my lord, in the violation of the Elections Act itself. Because, my lord, there was a requirement that once the tallying is done and the verification done under Article 138(3)(c, it was not the chairman but the commission that was required to undertake that process. And my Lord, I want to speak to the affidavit of the chairman himself. Other advocates have submitted on the self-importance that the chairman presumed in conducting the final tally, ignoring the mandatory nature of Article 138(3)(c). This court has dealt with the question of interpretation of statutes and of the Constitution, my Lord, where there's a compelling word, shall. Article 138(3)(c) is compelling in nature. It does not give the chairman an option of consultation or of assuming the role of the commission. It states, my Lord, that the commission shall undertake the process, not the chairman. The same term, my Lord, is used in the second schedule to the IBC Act and in sections 4 and 8 of the Elections Act. My Lord, if I may just read 138(3)(c). It provides, my lords, that the process of tallying, my Lord, after counting the votes in the polling station, the independent electoral and our commission shall tally. My Lord, where shall is used before a verb, citing my learned friend, senior counsel, it leads to an inevitable and compelling option. And this is what the courts have interpreted in several cases that we have handed over to the court, my Lord. The cases in Kirain Investments and National Land Commission, this was the finding of the court, again citing the findings of the Court of Appeal on the same question. Wesley, Judge of Appeal, laying down the consequence of the use of the word shall as peremptory. So, my Lord, that of itself, any action reflected in the affidavit of Wafula Chebukati that denotes any action by himself in assigning other members work, my Lord, and in eventually purporting to act under 138(10) alone without consultation, invalidates the entire result that he purported to announce and invalidates the issuance of Form 34C and D, in which he purported to announce the results of the election. My Lord, ipso facto, the duty to transmit, tally, and collate was therefore violated. The regulations, my Lord, 39(1)(c) of the Elections Act required two tallies, the physical tally and the electronic tally that ought to have been transmitted. Non-compliance, my Lord, is evidenced in the affidavit filed by Cherere and by the 4 commissioners, my Lord, and an admission by the chairman himself that the tally was not compliant with section 39(1)(d) of the Elections Act. My Lord, going forth, the complementary nature of compliance, sections 39 to section 44 uppercase A of the Elections Act, my Lord, denotes non-compliance by the commission, but also an admission, my Lord, that there was no commission the moment the commission was divided and was working in different forms. My Lord, Article 3(2) of the Constitution provides that there shall be no government established other than through the Constitution, so that any violation that leads to an unlawful process, my Lord, cannot stand. And this court has the duty under Section 3 and Article 140 to invalidate an offensive action that is unconstitutional. My Lords, we submit that through the affidavits that admit the interference with the transmission system, the interference with verification, and the duty to declare the presidential election by the Commission. The result gazetted in Gazette Notice issued by the chairman, being Gazette Notice 9773 of 2022, was unconstitutional and cannot stand and must be invalidated by this court. My Lord, in view of time, we wish to submit that even aside finding that even the duty of the Commission as created and enshrined, my Lords, in Article 249, is governed and dictated by the principles under Article 10, my Lords. And my Lords, where public officers do not act in a manner donated by Article 10, then their actions must be vitiated by the court. And this is the forum where such actions must be vitiated. My Lords, the law is clear. The maxim ex turpi causa non oritur action, which has been developed over the years, my Lord, by Lord Mansfield, initially in Holzman versus Johnson, later in Tinsley and Milligan, and now in Patel versus Mizra, speak to the fact that no circumstance can allow this action to stand. The opposing affidavits, my Lord, the opposing affidavits filed by the 4 commissioners and the 3 that speak to the violation of paragraphs 5 and 7 of Schedule 2 can only lead this court compellably, my Lord, to find that this is a matter that this court must handle in the manner that lex arbitri would dictate. My Lord, this the principle, ex equo et bono, used by international tribunals to settle questions. In the local framework, my Lord, we refer to Solomonic wisdom in 1 Kings 14. The court should look at the opposing affidavits. The court should look at the misconduct of the chairman of the commission. The court will then compellably apply the dictates of fairness in this matter and find that the people of Kenya were violated by the conduct of an election outside the framework of the Constitution, through the violation of the process, through the violation of the outcome. And my Lord, we want to demonstrate to the court, before I wind up, that mathematically, and this is where the law meets mathematics, no candidate attained the 50%. If the chairman read the results that he read and the percentages that he read out of the registered voters that cast their votes, my Lord. My Lords, the maxim, amiable compositeur, that I shall look at after my learned friend, Mr. Omtata, presents the results, my Lord, will show you that this court has no option but to nullify this election. There's no option. There's no option. Mr. Omtata.
Gather because you're all senators, you're learning friends now?
Yes, my Lord, Mr. Omtata is a serial litigator and a public interest, a public defender in this country. And I respect him for that role, my Lords.
And now a senator? And now he's a senator?
Yeah, he's a senator for Busia County. He replaced the Attorney General, who did not run for office.
Members of the Honorable Court, in my submissions, I will rely on the petition we filed jointly with the 3 others, which is dated 22nd of August. I also have submissions which I filed alone, which are dated 26th of August, And I also have a further affidavit, which is dated the 29th of August. My lords, before I remark on the mathematics, I just wanted to make a small observation as regards point number 1. And I think the elephant in the room is point number 1. What kind of election does the Constitution of Kenya anticipate? That's a question that I've seen documents and videos by some members of the court telling me that even this court does not comprehend the kind of election anticipated under Article 81 and 86 of the Constitution. Short of a digital election, you cannot meet the constitutional threshold.
Mr. Mutata, what
Yes.
did you say?
I said I've come across publications and video recordings by some members of the bench who complain that the 14 days the court is given to determine a dispute concerning the presidential election is too short. And I'm saying that statement demonstrates the failure of, with due respect, the honorable judges of this court to understand the electoral architecture in the Constitution of Kenya 2010. The Constitution of Kenya 2010 only anticipates a digital election. And if we are dealing with a digital election, 14 days is too much. But if you are dealing with a paper election, a manual election, you need maybe 2 months. That's where I wanted to begin. And this election does not meet the threshold in the Constitution at all. The presidential election, the one I'm referring to, that's before this court. It's not simple. That's why you have got spoiled ballots. In a digital election, you don't have spoiled ballots or rejected ballots. And you don't even have the question of whether the spoiled or rejected ballots count. It's not verifiable. Right now, I cannot verify where the ballots I cast went. I don't know. The moment I dropped them in that box, I lost all contact with those ballots. There's no mechanism of verifying. A digital election would give me a serial number by which I could track my ballots. So I'm saying that if you look at the threshold in the Constitution, we must work towards a digital election and move away from these paper elections, which allow human interference without sometimes leaving footprints. I would now go to my submissions. I was supposed to be given some aid. Yes. Where's the...
If the time could stop running, we had supplied the electronic instruments to the court.
You beg the assistant.
Okay. I don't understand what you said. I come there. Oh, open for me the PowerPoint document. Go to the next slide. Yes, we're looking at an analysis of paragraph 26 of affidavit filed by Mr. Sunkuli in petition number 7, paragraph 26. And you can see that he's giving us, he gives data of how the KIMS kits transmitted on 9th August at 17 hours at the close of polls. He gives that figure. On 9th August, at 20:45 hours, about some 3 hours and 45 minutes, he gives his figure of 13 million. Then, most surprisingly, you have two entries. It is the entry that which gives us at 14 hours and 14:40 hours. The KIMS kits are transmitting some 23 hours later, still transmitting data. And we're saying that that data is not acceptable. So we come to the next slide. I'll just run through given the short time I have. When you got that slide, you look, they tell you at 20:45 hours, on 9th August 2022, some 13,731,215 people voted. Polling turnout recorded on 10th August is 14,239,862 ballots. And on the 10th, that is the day after the voting, and we know that it's only elders where elections were taking place. Now, when you analyze that data, you find that 508,647 ballots are added on the 10th. And you saw Land Council Willis show that the audit of the register had almost the same number of ghost voters. So you can see from that data that they present, Mr. Sunguli presents, you are able to isolate 508,647 ghost cast votes, which are more than the difference between the two leading candidates. We've got the next slide. And if you look at the ballots that are recorded to have received, to have recorded on the next day, you are talking of some 1,665,412 curiously cast votes, which are coming out after the close of voting, and that's after 3 hours after the close of voting. So if we take the total tally now, you find that the tally is close to it's about 1.7 million votes. That spike in votes is not possible. That spike in votes is part of the problems we're having, that fellows were having access, the KIMS kits that were still transmitting data from locations that are not clear. Because the KIMS kits that were in polling stations, the voting stopped on 9th. And giving an allowance of 3 hours or 4 hours for people who are still on the queue, you would understand by why a KIMS kit would still be transmitting 23 hours after the close of elections is something that is difficult to comprehend. Also, my members of the Honorable Court, if you look at the Form 34C that has been published and interrogate the data there, if you look at the total of the variables ascribed to each candidate, the amount that you get is 110 votes less than the number that has been printed on that paper. Now, if you look at, that thing was boggling my mind. Initially, I thought it was a simple error of addition.
But just come out, it was not a question of 1 + 1 = 3. Because when you look at paragraph 32 of the replying affidavit of Mr. Sunkuli, yes, I'm on, yes, go to the next slide. Next. Yes, sorry, I forgot to, thank you for directing me. If you look at paragraph 32 of the replying affidavit of Mr. Sunkuli, the total voter turnout in the table when you subtract from it, as given in the table, the number of rejected votes on Form 34, you get exactly that figure of 14,213,137, which in that replying affidavit they claim was an error of addition. But if you interrogate their raw data, you find that that figure is the valid figure. So the votes attributed to the candidates are fictitious. From paragraph 32 of Mr. Sunkuli's replying affidavit. So when you go on to the next slide. I've reproduced I've tried to factor in the figure that Mr. Sunkuli gives, and when you add them, you get the 14,213,137. Yet, when you add the figures attributed to the individual candidates on Form 34C, they come to 14,213,027. That is not an innocent mistake. It is a situation whereby somebody has left a trail that they were working backwards from a certain figure which they had, and they were working backwards, and so they would going to get that. And most important, I would also refer to the affidavit signed by the chairman, filed by the chairman in petition number 5. At paragraph 95 of his replying affidavit, sworn on 26 August 2022, the chairman presents the exact figure of 14,213,137 as the total valid votes cast for all the 4 candidates. So if that is the figure that's coming from the raw data, that's the figure that's carried in the affidavits, then the values attributed to each one of the 4 candidates are fictitious and cannot count. And therefore, that Form 34C is an invalid document. Go to the next slide. Sorry, next. Yes, so in that slide I'm saying, we can only conclude that these figures, which form the content of Form 34C, are cooked. You cannot have both of them in the same document. And this court should not allow that document to stand at all. And the conflicting figures, and those conflicting figures for valid votes cast of 14,213,137,000, and the other one is the one when you add the values of the individual candidates, the 4 candidates, you get 14,213,027, is evidence that the results were worked backwards to achieve a desired or predetermined outcome. Therefore, the declared percentages for the 4 candidates, no, the votes attributed to the 4 candidates and the declared and the percentages attributed to them is all fiction. Now, I go to address the question of whether you can achieve, assuming that what in the totality of the announcements made by the chairman, any of the candidates realized 50% plus one vote.
Just checking on the time.
Yes. There's no display for the time, unfortunately.
According to mine, time is over. If you could just finish your slides.
Okay, thank you.
Because they seem to have lost theirs.
Okay, so a further analysis of Form 34C on voter turnout, the chairman announced, and that issue has not been retracted at the close of voting. He was answering a particular question, and a journalist asked him, as matters stand now, what is the national voter turnout? And he said, oh, that one, I can deal with it. And he said, as at the time he was announcing, it was 65.4%. And according to what the KIMS kits had reported. And he expected that value to go up when all the KIMS kits had reported and the manual had been included in it. So when you calculate that against the total voter register, the national voter register of 22,120,458 votes, you get that the voter turnout as at that time was 14,466,799 votes. The next slide. So from Form 34, the tallies are ascribed in Form 34. You get, when you factor in the rejected votes, you get a total value of 14 million.
Two, 3, 4, 5, 6, 7, 8, 9. Melang, 100. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 110. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 120. 1, 2. 120.
Confirm the counterpoints. We need to move to the next box as we agree on our notes on the forms. 225. Any contrary number? So 225 it is. The forms we record. What do you make of the forms? Let's have 2 comments. Yes, yes.
And therefore he decided to abandon the first one, which was not signed, and went to the other one.
So whatever happened for you, one form is unsigned, another is signed,
Yes.
and even signed by them.
Yeah,
So we'll
if
just
you-
note the two.
Yes.
I don't know if there is, do you have a different opinion for those who have seen that we have two forms, one unsigned, populated, yes, but unsigned, then one which is signed. So depending on what happened, we don't want to speculate, but we'll just have that in the report.
That is required under Article 138.4, 138, Clause 4, Paragraph A. And so, with those few remarks, I pray that the Honorable Court allows the petition and the other petitions, and then...
My Lords, I had intended to make the prayers in lieu of the jurisprudential weight of the mundane questions that I would want this court to
Sorry, Senior Counsel. Can Mr. Omutata confirm? I'm trying to go through the record. This PowerPoint presentation you just made, is it part of your pleadings?
Yeah, it's part of my pleadings in the law.
Word for word?
Yes, word for word. In fact, I'm just cutting for purpose of highlighting.
Okay, thank you.
I will do it.
Unless you are changing, that is not word for word.
No.
So if it's word for word, we don't need any other copy.
But of the most important is the father affidavit. Because when I did the first one, I did the petition, I did not have the information that came from... I did not have the information that came from Mr. Sunguli's affidavit. So I would request the court to pay particular attention to the father affidavit. That's why I had the benefit to compute the figures with the figures that the commission supplied. That's all, my lord.
Thank you, thank you.
Compelling are the figures that finally mathematics finds its way into invalidating a
So, General, you have
presidential
no leave to address the court after time. Why don't you start from there? From where? From what time? Start from there.
Senior Counsel, we agreed on the ground rules yesterday. Your time is up. In fact, his time went over because he was on the PowerPoint. We noted he went over by 6 minutes. So please, yes, if you have anything, you can reply when you have time to reply. Rejoinder. I will now invite counsel in petition number 6, Julia Yokabichege and others.
May it please, Madam Chief Justice, Deputy Chief Justice, and other members of the court. My name is Kibe Mongai, appearing with Ms. Wairi Mokeru for Julia Nyokafishege and 3 others. First of all, let me say that I'm very happy to be responding last, and particularly to have had that very good presentation by my long-term friend, Mr. Okiya Omutata. My Lord and my ladies, the petition before the court has been introduced. The petition is dated 22nd of August this year. It is supported by 2 affidavits, an affidavit sworn on 22nd of August by Julia Shege, and a further affidavit that she swore on 28th of August, 2022. We have done submissions which were filed on the 30th of August 2022. That is when they were stamped. And we have also done a bundle of authorities as required. Now, having introduced the pleadings that we have filed, I wish to, looks like I don't have the petition, but basically the petition before the court, the petitioners are basically arguing for invalidation on the simple ground that there were so many violations of the constitutions and the electoral law by IEBC and its chairman, as the case may be, and as a result of which, those violations constitute such severe illegalities and irregularities that the results announced ought to be nullified. We have pointed out, for purposes of the specific issues raised by the court, we want to dwell with issues number 6 to 9 that were identified by the court. And to sum up, because before we go to the exact issues, is we shall basically be talking about 3 violations before we refer to the conclusion. Now, the first issue is the fact that over 700,000 people who ought to have voted during the general election held on 9th of August were deprived of the opportunity to do so. Number 2, we shall be arguing that the third respondent, that is the Commission, contravened or violated its duty of accountability, transparency, and public participation during the 4 stages that we shall shortly be outlining, and in a manner that it declared the results of the presidential election. The third issue that we shall be referring to is the fact that the third and fourth respondents violated the procedure set out in Article 138 of the Constitution in discharging their mandate of tallying and verifying the vote at the Bomas of Kenya. I start with issue number 1. The constitutional basis for issue number 1 is Article 38 and 138A of the Constitution. And in this, we are referring to the number of people, 700,000 by our count, who ought to have voted and were deprived of the opportunity to vote. Now, what is a complaint? The complaint, members of the court, is laid out at paragraphs 56 to 60 of the petition, paragraphs 56 to 60 of the Constitution. And the supporting evidence is laid out in paragraphs 24 to 28 of the supporting affidavit sworn on 22nd of August, 2022. The long and short of those paragraphs is that the petitioners are basically saying that by virtue of Article 1 of the Constitution, the people's sovereignty is exercised in Kenya by 2 major methods: through voting, and collectively we only exercise that right during a presidential elections. And number 2, by voting in a referendum. Now, under Article 38, it is expected that the right to vote for a candidate of your choice is recognized. The same way under Article 138(3)A of the Constitution, voting at a place appointed by the IEBC by all persons eligible to vote. Now, on that basis, Regulation 90 of the Elections General Regulations Act, General Regulations 2012, were done under the Elections Act. Regulations 90 provides, is a short provision that I need to read, that the Commission may make provisions for the voting by election officials, observers, patients admitted in hospital, older members of the societies, members of the defense and security forces on duty, prisoners and nomadic pastoralists, and other persons who by reasons of any special need, including disability, are unable to access a polling station. 2, the Commission may from time to time publish notices on the manner and procedure of the conduct of special voting, and such notices shall be read as part of these regulations. So the long and short of it, but I want to tie up with the facts, in paragraphs 50, the petitioner says no such notices were issued with regard to the persons in contentions in this particular contest. Who are those persons? Those persons include at least 500,000 elections officials. They include at least 180,000 members of the security forces. It includes those people who are in hospitals and others who may not be in hospital. But they are placed in such circumstances that special arrangements ought to have been done to ensure that they were able to exercise their rights under Article 1 and Article 38 of the Constitution. Now, why have we chosen the figure 700? The figure 700, as you will see from the affidavit, has been chosen for the simple reason that there should be no contentions about it. These figures, these are elections officials. The IBC chairman is quoted in the newspaper report that is attached to that affidavit, in fact confirming that indeed all this number of peoples will be engaged during the election day. Their engagement during the elections day follows up of necessity and in the nature of their duty that starts at earlier than 6 a.m. and ends long past the counting period, that those are the people envisaged under Regulation 90, that special arrangements to ensure that they vote would be made. It is not denied, in the face of these complaints being made, that those arrangements, in fact, were not made by the Commission. Now, it is important to point out these regulations were made in the year 2012. Of course, it is interesting to know, faced by these complaints, how did Chebukati answer them? He answered them in his affidavit by first of all saying prisoners were allowed to vote under Regulations 90. He says diaspora Kenyans were allowed to vote under Regulation 90. And he also says very old people and sick people would be first on queue, and so such instructions were issued to ensure that those kind of people would vote first with a little bit more convenience than others. But, Your Lordships, it is important to note that when it comes, for example, that prisoners voted, prisoners have been voting in Kenya in the presidential elections, not so much because IBC has been complying with the law, but because I believe it was Judge Lenaola, when he was at the High Court, made an order first that prisoners to vote in the presidential elections, and number 2, in the referendum. And that was done. Even the reasons why diaspora voters vote in Kenya is again because of another subsequent court decision. So that where we stand today, for purposes of Regulation 90, the IBC cannot give a single instance that in support of ensuring that as many Kenyans as possible will vote for the presidents of Kenya and exercise their rights to franchise has ever done anything. There is no evidence of that. Now, during the preparation of this petition and afterwards, for purposes of these kinds of violations of the right to franchise, it is a very serious thing across the world, because as many of us are entitled, and that is why even this right was given to prisoners, to ensure that we vote. You find in very many other countries where elections have been nullified because of the issue of franchise. But you do not have a single instance, at least to the best of my knowledge, that this has ever happened in Kenya. And this could probably explain why, even after the Constitution is clear on this issue, that facilitations be made to ensure as many people as possible and those in special circumstances, those arrangements have never been done by IEBC. It is my submissions that given the results that were declared on the 15th of August this year, voting by up to 700,000 voters, even if that was adjusted, how many of them could have been registered and how many of them could actually have voted to the actual averages, you would still have arrived at a very big figure of more than 300,000. That directly and on account of non-compliance with an express provision of the law were unable to vote. Did the failure to make that accommodation, those arrangements, to ensure those people voted affect the results of the elections? Undeniably. If those people had voted, it is our submissions that the results of the elections could have been affected. And my Lord, it's in my submissions that unless and until this honorable court take up that issue as a serious issue of violations of constitutional law, then Regulation 90 could as well be an empty piece of legislation. And therefore, part of the enforcement of ensuring that the universality, that the free franchise and universality of it is respected would be to ensure that a very serious elections was violated on its account. And it is on that reason that when we read our submissions, we are urging the court to do exactly that. Issue number 2 has got everything to do with the fact that the duty of accountability and verification, as we had said, was violated at various stages. It is my submissions that there are at least 4 stages in which this happened. Number 1, stage 1 ordinarily occurs the stage between 20th, the election period. A Gazette notice was issued on 20th of January to signify the commencement of the election period. That period ended on the 8th of August. Then there is stage 2, voting day. Then there is stage 3, which is a 7 days period under the procedure set out under Article 138 of the Constitution. Stage 4, in my submission for purposes of the presidential election, it is the 21 days period under Article 40 of the Constitutions that you are dealing with right now. Now, what are the stages at stage 1? The issues at stage 1, and I will link them up with how they tie to the elections, is the fact that in this particular case, IEBC, according to my clients, was supposed to ensure that they set up a technology system that was transparent enough to ensure that the outcome would have credibility in the eyes of the electorate. The one single issue that we have pointed out for purposes of that in an elections where you've said you have recognized voters using KIMS kit, it has been recorded, it is our submissions, that on day 1, in their affidavit they say 6 hours, that at least 6 hours after the conclusions of voting, Kenyans ought to have known what many people voted electronically and using any other complementary system of voting. And my lords, it is my submission that the failure to do that, one cannot be able to speak of a technology that worked if the most important component that a voter ought to know, the right of a voter to know, yes, we voted. If we reach this number, this man is president. If we reach this number, this one is president, or is in the opposition. That number ought to have been given without any dispute. There should be no controversy about it. Yet the fact that you have all these controversies about the register just points out to the issue that on that critical element, there was serious failure of that technology. But it may not necessarily have to be a serious failure of the technology, in the sense that it could well be that the manner in which now you conclude voting, Forms 34A were uploaded, But the actual figures were being named on day 2. This is day 2 after the arrival of all forms 34A. It is our submissions and my hypothesis that any person, and nowadays there are so many books that you can read anywhere and you can buy anywhere, that says how do you rig elections. If one was set out to rig an election such as this one, then one of the most important variables would be the voters' register. And in this case, it is our submission that the fact that on day 1, 6 hours after the election, we were not told in a controversial manner, and after Kenyans have invested in a technology, that this number of people voted. This opened the system in the subsequent verification process to the kind of abuse that more other able people in that area have spoken about today. But that, on the face of it, appears to be where the opportunity arose. I go to the issue of still at stage 1, the issues of the nomination. We have said in our affidavit that for purposes of Article 99 of the Constitution, the presidential candidates were supposed to be subjected to qualifications under Article 99. The manner in which that was done for purposes of presidential election, the second respondent was actually not subjected to it, and at the end of the day, persons with unresolved questions under Chapter 6 is today Deputy-elect of the Republic of Kenya, arising out of the failure of IEBC to enforce the law. The next issue is the publication of a Gazette Notice number 9540 on 8th of August. This Gazette Notice in our submissions was an instrument of illegality. My learned colleague, Mr. Nyambodi, says that IEBC chairman is always inclined to produce Gazette notices even when none is required. I read it differently. If you read Gazette Notice as an instruction manual, it makes a lot of sense. In this sense, that in the ordinary scheme of things, and particularly when I was working in the human rights movement, when you deal with a lot of police officers and other people on those junior ranks, this activity will be carried this way. They'll not tell you the Penal Code says this, the Police Act says this. They will tell you the forces standing order, which they are socialized to understand, says this. So this was the forces standing orders. So that for purposes of the day when this verification was being carried out under this, what we are calling stage 2, it was being, and it was published on the eve of the election. There was also the bad faith that on the eve of the elections, you publish such kind of a Gazette Notice that runs directly counter to the Constitution. Why would anybody do that in good faith? There was lack of good faith. Because in the Republic of Kenya, during my practice of a couple of years in public law, we are aware this is the kind of stuff that we present in constitutional division and the judicial review courts to confirm whether or not it complies with the constitutions or statute. Therefore, when you publish such a Gazette Notice, an instruction manual that would be deployed during the verification exercise, and the following day is a public holiday, you cannot be taken to have been done that with the best of intentions. We got to stage 2, voting day. Voting day, the first violations that we talked about, not everybody entitled to vote under Article 138 in the presidential elections actually voted on account of non-compliance with the law by the IEBC. The second issue for purposes of that day, I've already talked about it, is a voters register. That on the elections day, and we have said 6 hours, you needed to know how many of us voted. The moment that information was not provided, the system and the process was exposed to anything could happen. And actually by the 15th of August, the worst, and all that could go wrong actually went wrong on the 15th of August. And therefore, this is why we are saying these violations were not just minor violations. They were violations that indeed went into the heart of what is before this court, the disputed elections. At stage 3 is what we call the procedure under Article 138. Well, my constitutional law mentor, Dr. Gibson Kamau always used to tell me, and I believe most of the people who had the privilege to be his pupils, that the Constitution must be understood in a historical context. And therefore, it is important that we understand Article 138 in a historical context. What is this context? This context, my lords, is this, that we do not have an equivalent of Article 138. We do 6 elections. The Constitution has not told you this is a procedure at the parliamentary elections or the governor or anybody else. It is only reserved for one position, the president position. The procedure are the presidential elections. And this was to leave no room of doubt that this is how in which the verification process ought to be carried about. My lords, the process after we vote in a presidential elections, I first voted in 1992. And since that year, the first multi-party elections, after voting, of course in Kenya they tell you, vote, go home, watch it on television. You will get to know the outcome. How it has always worked is that you are there at home, results are read from constituencies, from everywhere else across the country. It is a ritual that happens every year as far as I can remember since the year 1992. Now, what is the importance of this ritual? It is important to remember that in the year 2007, this ritual was disrupted by the events that happened at KICC. The disruptions of this ritual led to the post-elections violence, and the rest of it we are all aware what happened after that. So that it is not a simple ritual. And so that in the year 2010, when the Constitution was written, it provided for a sections and 7 days and a procedure, setting out in no uncertain terms, this is how, after people vote for their president, we are going to process the issues. So that the Constitution, having dealt with that issue against that historical background, you cannot have a situation where subversion through a gazette notice is tried to be effected. That would be treason in every sense of the word. I go to the issue of what's the importance of the ritual. To the winner of an election, this ritual that we saw in this constituency, what you got in my neighborhood, is very important. Because the people, while we are seeing all this being displayed, and remember that during bombers, the display to show Kenyans that these are the results that were coming in, this is how the figures were adding up, that was disabled at some stage. So that what effectively this meant, that the true purpose of Article 138 ends up being defeated. Defeated in the sense that for the winner goes and declares that I had the most numbers in accordance to Chebukati. And the loser, everybody else says, I do not know how you got those numbers. I actually thought I had more than you had. This is what was tried to be prevented. But it is equally important, the procedure under Article 138 for the loser. Why is it important for the loser? Because the loser, and in this case the loser is a loser with say about 6.9 million votes, quite a number of Kenyans. This is a loser on his 5th time seeking the presidency. The last one he says he lost under controversial circumstances. There was everything necessary to ensure that for purposes of these elections, if you are to lose the election, the math must make sense. It must add up. The Kenyans, those people who voted for you, must also see that you did not do very well because it is clear these people in that other place did not vote for you as you expected. Now, but when you have now a true situation on the 15th, the dramatic events of the 15th of August, where even 27th constituency, my clients are there waiting at home, I was also equally waiting at home. Those results are not announced. Then how do the people who are supposed to be losers understand that they genuinely lost in the elections? That would strip the process of legitimacy. But it is equally important for another reason that Wallace Soyinka talks about in one of his essays. And I believe the essay is published in a book called Climate of Fear. And Wallace Soyinka, in an essay titled The Quest for Human Dignity, says that in war, it is important that those who lose a war should not be stripped of their dignity. And basically what this means is this, that even after losing war, you are not stripped naked in the sense that you are told you lost half of your country, but you must be left with the other half. That is if you are in the Russia-Ukrainian kind of situation. That is a whole idea that nobody should lose absolutely. And when the Constitution talks about fairness, about transparency, it is to enable that this is processed in a manner that everybody else would be able to understand and to process the victory or to process the loss, if it turns out that it was a loss. Now, we go to the issue number 4. I wish I could say more. I'm just trying to watch myself. Stage number 4, the final issue is the Supreme Court issue. We served Chebukati with our affidavit. And I would not say he's arrogant because that may not be a permitted language. But the language that used is one that shows lack of remorse. You will read the affidavit. On the issue of why didn't you make arrangements for everybody to vote? We were talking about specific people, election officials. Then he says, oh, prisoners voted, diaspora's people voted, and all these other people voted. Now, that was not the issue. I think they are needed, and this is accountability to the Supreme Court. And that is the design of the Constitution. That now that a violation has been committed, what do you have to tell the court about it? You could not even say it was an oversight. The next one I will recommend to the next chair to ensure it is done. There was no such thing. Then we go to the next issue. In our affidavit, the third petitioner says, I was disturbed about the events of 15th because in the morning of 15th at around 7:30 a.m., I was shown some text that seemed to show the results that now are being announced later. Why was it disturbed? Because at that time, votes were still being counted. People are being told in constituency A, this is what people got. How does Chebukati react to that? Oh, everybody with a good calculator could have downloaded these forms 34A and calculated. Now, Kenya is a country with extremely low digital literacy. To say, and when such a thing that would cause concern, that there was a problem, and you say this information was readily available, leaves a lot to be desired on the part of a public officer. I start with finishing with the issue of legitimacy. It is important that winners should have legitimacy. And it is also important that the losers also should be treated with dignity. When we read the affidavit of Honorable William Ruto, he says, oh, so many people, why are you pretending that you are acting for all Kenyans? So many people agree with my victory. But it is also equally true, so many other Kenyans don't agree with it. And therefore, in a constitutional democracy, as I conclude, it is absolutely important that when you win, and Article 38 says you win it this way, it must be confirmed. Thank you very much.
Thank you very much, Council. We would like to take the submissions by, I think, 4 respondents who are supporting the petition. That is the 4 commissioners. According to the time schedule we allocated yesterday, they were to share the 1 hour. But before council, you take the podium, we are proposing just a 15 minutes health break. Then we come back because we will hear those submissions. And if there are questions from the bench to all the submissions that have been made, they will be directed to council. So we'll need about 1.5 hours when we return to finish today's proceedings.
Tire, on the word from Justice Lenola, could the court find out what's happening to the question of scrutiny? Because it looks like we still have a crisis.
Yes, we shall. I'm aware.
Minwa, Agal Toto, Abebo. It's been a while, but you're looking so fine. And let me ask, have you eaten? Have you taken lunch? Don't punish yourself. Let me wire something kidogo kwa simu. Is 70,000 enough? Hii weather iko na baridi hawa. Should I book some hotel in Diani or Zanzi? And let me ask you, will you use chopper, business class?
We've come to the end of AgriTalk.
Thank you so much for keeping it here.
Maisha Kilimo, a weekly agriculture show on Radio Maisha. AgriTalk on Spice FM's morning show, The Situation Room, and Grind na Agribiz on Vibes Radio morning show, Morning Vibes. Find us online.
Petal Care has a floating design that perfectly fits. It reduces 70% friction on skin, absorbs.
From here, the ones that were 2. Please confirm that it is now inside here.
The form?
The result form that was in 2.
So this result form at 4A?
Okay, good. Close it.
Seal?
Okay. Okay. So let's have seals to close 5. Dr. Masha, you said 2? So 2, 3, 6. The markings against this register. 2, 3, 6. Yes? 236. Allow me to then have it sealed. Once we agreed on that, give it to the other team. No, this is 6. Give it to the other team. Okay, just please talk so that the rest can hear your concern. That's why we are all here.
Let's just counter check because the votes are 235. That's valid plus rejected.
would we confirm that the register talks of 236 or 235?
So both the form and the results as declared per the form, and what we have counted is 235, isn't it? So the issue is the register. They can still do that even as we close this. So please do that. Recheck again the numbers, 235 or 236. But let's close. Let's close this box.
Okay, so seals for ballot box 5 of 7. So I go to seal 1. Seal 1, 067 9652. 067 9652. Sorry? Okay, seal 1, 067 9652. 067 9652. Second seal, 067 9651. 067 9651. Seal 3, 067 9650. 067 9650. Next seal, 067 9653. 067 9653. Aperture 002 8690. 002 8690.
Thank you. We are done with that ballot box. Now we are on 7 of 7, and we'll be done with Mvita.
Okay, so Mvita 7 of 7. Ballot box serial number. I'm reading 374085. 374085. Aperture serial number. Yeah. Sorry. So box serial number, I repeat, 374085. 374085. Aperture seal serial number 0028661. 0028661. Seal 1, 0028677. 0028677. Seal 2, 0028678. 0028678. Seal 3, 0104299. 0104299. Seal 4, 0104300. 0104300. I repeat the last one, 0104300. The first one was 002867. 78, was that the first one? The first one was 77. First one 0028677.
So as per the PSD, the serial number of the box 374085, 374085. The seal of the serial number that was used to seal the aperture, that is 0028661. 0028661. Now the seals. The first seal, 0604300. 0104300. The second seal, 0104299. 0104299. Then the third seal, 0028678. 0028678. Then the fourth seal, 0028677. The contents?
Okay. The contents? have the first, most of them are not in parcels. So we have
unused ballot.
So this unused
papers.
It's freestanding. Rejected votes. Another parcel, counterfoils used. Used seals. We have so much seal. This should be
the valid votes.
This should be valid votes. Some have spilled out. Sorry.
Yes, please note your concern.
Just wanted to say that we note that the ballots were not in a sealed envelope.
Yeah, they look like zimetokana. Okay, some. So just note that some are inside, are sealed. They are not sealed.
Zero 63 8894. 0063 8894. Second, serial number for the first batch was PR00638845. PR00638845. Last serial number PR00638850. 00638850. Batch 3, first serial number PR00638851. PR00638851. Sorry. Last serial number PR00638876. PR00638876. Last batch, first serial number PR00638895. PR00638895. Last serial number PR00639099. PR00639999. Those are the 4 batches. We set them aside. So we go to unused ballot papers. First serial number PR00638844. PR00638844. So this one is just one stack on the cover. It's one stack on the cover. So the bigger batch, the first one, PR006391 00. PR 00639100. Sorry? The first one is a standalone stack.
Is this,
the cover.
Is this a ballot paper? I don't think. Looks like it's a counterfoil.
It's a standalone counterfoil.
Let me see.
Stack on the.
Just let me see.
Yeah.
Okay, just take that. Take what he's saying. We will come back to this.
Okay.
Yeah.
So I'm repeating the first serial number. PR 00639100. PR 00639100. The last serial number, PR 00639495. PR 00639495.
So those are unused. This one is a counterfoil. So this counterfoil has serial number PR 00638844. Yes, because it's stuck here, but it's a counterfoil.
Okay.
Check the serial number again.
PR 00638844.
So if whether it's first, second, third, or the one that has 445, this should be the first one on the 45.
Okay. Rejected votes. Rejected votes. Okay. Rejected votes. The first one, 1, and 2. 2 rejected votes. Used seals. We have 4. So we are going to valid votes. Valid votes, we have 1, 2, 3, 4, 5, 6. We have 6 rolls. So we'll proceed to
So please note what is happening here. These rolls, because they are all together, they have to open and then check each roll. Yeah. So we noted that they were not in the seals, in the polythene. Yes. Yeah.
We open on. Let's open on. Just 1 minute.
1-1, I think deal with that, isn't it? Yeah. So, Honorable Were, what you have, just tell us they are in respect to who, in favor of who?
This one is in respect to William Samoei Ruto.
You have confirmed?
Yes.
Yeah, Ziweke Izo, so you are holding those ones?
William Samoei Ruto. So that's the second batch.
Give them to Were. Okay, give them to, you receive them.
This is William Samoei Ruto.
So you have them? Raila is here, yeah.
Wajakoya.
Weka katikati. So let's start with the one.
There's one.
Yeah.
There's one, yeah.
No, it's okay. Just tell us. So if it's we have confirmed, we can start counting those ones. Please count.
You click on the thing.
Mm.
You click on the thing.
Yeah.
Okay, we are counting Wajakoya. We are counting George Wajakoya. One. No, it's not one. Two, George Wajakoya. Three. Four. George Wajakoya, total 4. Oh, sorry. Okay. For David Wahiga, we just have the tallying sheet, so there is no ballot cast on his favor.
Okay, so let's start. Yeah.
Okay. We're starting with the batch for William Samoei Ruto. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33, 34, 35, 36, 37, 38, 39, 40, 41, 42, 43, 44, 45, 46, 47, 48, 49, 50. Those are 50. We'll now start from 1. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33, 34, 35, 36, 37, 38, 39, 40, 41, 42, 43, 44, 45, 46, 47, 48, 49, 50. That's the second 50. We'll now start from 1 again. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16. So that's 50 plus 50 plus 16. That's 116 votes for William Samoei Ruto.
16.
116.
116.
Yes.
So we go to the next. Yes. Raila.
These are the ballots for Raila Odinga. Okay. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33, 34, 35, 36, 37, 38, 39, 40, 41, 42, 43, 44, 45, 46, 47, 48, 49, 50. The first batch, 50 ballots for Raila Odinga. We're moving to the second batch.
This polling station didn't have rubber bands. I think. Yeah? All sides of. Oh, really? But they're untidy.
Okay, we're starting with the second batch. 1, 2, 3.
Anyone who had
4.
any issue with any of them, that was the time to raise the issues. Again, the law is clear about how one can complain about a commissioner enjoying constitutional security of tenure. So do not be influenced with innuendos and insinuations about these 4 commissioners. They were vetted by the people's elected representatives. Now, coming specifically, this is the second fundamental submission I'd like to make. This so-called walking out from Bomas, look at the affidavits of the 4 commissioners. The vice chair saw 2 affidavits, so there are 5 affidavits in total. And I invite this honorable court, when it retires, to read through those affidavits in their entirety. We adopt them. We rely wholly on the averment in those affidavits. And you will find in those affidavits that all that these 4 commissioners were demanding of the chair at Bomas at the tail end of the tallying and the verification. Their narrative, which I invite this court to accept, is that they were not involved in the tallying and verification, and in particular regarding the 27 constituencies. So they were demanding of their chair, you cannot bring a paper here and tell us that these have been verified and tallied by the chief executive. The work of the chief executive is to implement decisions of the commission. He is not part of the commission, any more than the registrar, the chief registrar, implements, or any registrar of the High Court, implements the decision of the judges, not the other way around. So they were saying, we need to tally and verify the results in respect of these 27 constituencies. And the chair would not allow that, which was typical of the relationship between the chair and these 4 commissioners. And a twist is being given that it is these 4 commissioners that wanted to force a runoff. It is the exact opposite, your ladyship and my lords, and that is what we state in the affidavits. It is them who were asking, how do we confirm that the candidate you are about to announce has received 50 plus 1 vote? And his response was, are you trying to force a runoff? I am not conducting another election. So this acrimonious relationship is what was there between the chair and his 2 allied commissioners and the other 4 commissioners. Now, I would like to submit that the 4 commissioners were fully justified in saying we cannot own results we have not tallied and we have not verified. The law has been referred to this honorable court severally that it is the commission that should do the verification and the tally. This legal notice that appointed the chair as the returning officer, you've been invited to hold that legal notice, that regulation is unconstitutional and valid because it contradicts the Constitution and the Elections Act. But beyond that, it is the chair himself alone who appointed himself as the returning officer for the presidential elections. You will not find any minutes of any meeting by the commission appointing the returning officer. So quite apart from the fact that it was unconstitutional, it did not have the authority of the commission. I would like to cede ground to my colleague Apollo so that we operate within the 60 minutes accorded to us. I ask that this court uphold the position of the 4 commissioners, that the results that were announced were not the results tallied and verified by the commission. I thank you.
The Chief Justice and members of the court, without wasting more time, I'll pick it up from where the senior counsel has left. My name is Apollo Mboya. I am on record for the fifth respondent. Your Ladyship and my lords, the actions of the chairman of the Electoral Commission can be evaluated using several instruments. And I believe the first instrument that we need to use in examining the whole issues that are before this court is the oath that the commissioners take. The oath is in the 3rd schedule of the IEBC Act, so that for every action, we juxtapose that oath to those actions, so that we test if the actions meets the tenets of that oath. And permit me to read what that oath says, and it's taken by all the commissioners. It states, I, then they say their name, having been appointed chairperson or member, as it can be, of the Independent Electoral and Boundaries Commission, do solemnly swear that I will at all times obey, respect, and uphold the Constitution of Kenya and all other laws of the Republic of Kenya. That is the oath they take. That I will faithfully and fully, impartially, and to the best of my ability, discharge that trust and perform the functions and exercise the powers devolving upon me by virtue of the appointment without fear, favor, bias, affection, ill will, or prejudice. That is the promise that they are giving to the people of Kenya and to the whole world. Now, for every action that the chairman did, which I'll not go into because this particular affidavit of the 5th respondent has been cross-referenced by my other senior counsel and also learned colleagues who spoke before me. We juxtapose those actions against that oath that they took. So, for example, if we are talking about issuing a gazette notice, you look at that gazette notice with the law, then juxtapose it to the oath, if it meets that promise that they gave. Your Ladyship and my lords, the 5th respondent is now affectionately called opaque. Affectionately. I say that because arising out of what transpired at the National Tallying Center, they issued, the 4 issued a statement in which they said they cannot own the results that were going to be announced by the chairman, and therefore they were opaque. Your Ladyship and my lords, that term opaque is not coming from the ordinary. It's a term that was given by the Court of Appeal when they were making a decision in another matter, which is now famous here, called the Maina Kiai matter, which when they were looking at the role of the chairman vis-a-vis the other commissioners. And the court did indicate that to suggest that one individual alone can tally and verify the votes for presidential election is to suggest otherwise, to introduce opaqueness and arbitrariness to the electoral process. Those were the words of that court. Members of the court, we might ask if the chairman, as indicated from the affidavits that we have had, that it was his responsibility alone to tally and verify the results, then the question is, what were the other commissioners supposed to be doing on that election day? Were they supposed to sit at home and watch the screens just like any other Kenyans? But then again, the chairman went ahead and allocated them duties. With respect to the fifth respondent was given the role of media. In that role, the fifth respondent was supposed to explain even to the media why what they were reading, the results they were reading, are not being projected on the screens. The results that they read were not projected from Friday 13th. And when that question was put to the chairman to refresh, the chairman said, no, I'm tallying from the back end. Your Ladyship and my lords, the sum total of this whole transaction is that the chairman usurped the powers of the commission. And it's our submission that after all is said and done, and after we get the reports of the verification, I believe that this court will arrive at a conclusion that the chairman of the Electoral Commission was actually an agent of a presidential candidate. That presidential candidate we will know by 5th of September. And if that's going to be the case, lastly, it's our submission that this court must go further and look at the theory of agency. All the conspirators that did any illegalities, all irregularities, are agents of one another. The person who benefited from those irregularities and illegalities is a co-conspirator with the persons who perpetrated it, and they are agents of one another. And for that reason, we would urge that this court makes appropriate decision with that particular issue in mind. I call upon my learned colleague, Dr. Marua, to take over from me. Thank you very much.
the Honorable Chief Justice, and the honorable members of the court. My name is Jotham Aroa. I appear for the 7th respondent, Commissioner Justice Nyang'aya. I will be making submissions on the following issues. Issue number 2, whether there was interference with the uploading and transmission of Form 34As. I'll also speak to the issue whether there were irregularities and whether the irregularities affected the results. I'll mention briefly something to do with the reliefs that this court ought to make, and also issue number 6, whether IBC carried out the verification exercise. So on the first issue, my lady and the honorable members of the court, the position of my client is that there were indeed interference with the uploading and transmission of Form 34As. My client maintains that this was done without the involvement of the commissioners, specifically the 4 commissioners. And it is their position, my lady and the honorable members, that it was done in clear violation of Article 81E of the Constitution and Article 86. Before I proceed, I wish to clarify that we have made reference to a number of authorities in our written submissions, but I will not refer to them because of time constraints. As regards interference with the ICT infrastructure, the Commissioner, in his affidavit, which has been filed before this court, and specifically in paragraphs 33 to 34, raises a number of issues. First, he maintains, my lady and the honorable members, that the server was accessed by unauthorized persons, and these included foreigners and some members of the IEBC. He mentions them by name. He further maintains that one foreigner by the name Gudino Omar accessed the server several times. He explains that a number of forms were pulled down and others uploaded. And he also maintains that there was revision of Form 34Bs. My lady and the honorable members, these allegations are contained in his affidavit, and I wish to point out that they have been responded to by IEBC. In their response, the first thing I wish to point out is that there is no denial that the logs that he annexed to his affidavit emanated from IEBC. The only contention being raised is how did he get them? That contention, in our humble submission, has no merit, considering, as he puts in his affidavit, that he was the commissioner in charge of ICT at the commission. If a commissioner who is in charge of ICT cannot access that kind of information, it is my submission that nobody else in IEBC can access them. The next thing that, and that admission, Madam Chief Justice and the honorable members, is found in the affidavit of Hilda Kavonga. That affidavit is filed by the firm of Iseme Kamau and Maema Advocates and is sworn on 27th of August 2022. And the admission is contained in paragraph 13, Roman 4. Beyond that, Madam Chief Justice and the honorable members, there is also an admission, and this, according to me, is a serious admission. There is an admission that the server was accessed by a foreigner by the name Gudino Omar, as mentioned in the affidavit of Justice Nyang'aya. But I wish to read to the court what is said as concerns this foreigner. At page 5, paragraph 30, Hilda Kavonga, she says, Gudino Omar is the technical lead for Smartmatic, who provides support on the technology provided by Smartmatic. He's the technical deployment lead, and then in paragraph 8, she continues, they said Gudino Omar, being a technical deployment lead, his role is to deploy infrastructure, that is networks, server platforms, and services. In his capacity, he is supposed to have access to the said infrastructure to monitor by ensuring the system is properly running at all times. Now, the first point that we need to bear in mind, Madam Chief Justice and the honorable members, is, did IBC formally gazette Gudino Omar as one of the persons who had access to the server? Secondly, IBC is enjoined under Article 81E to uphold the secrecy of the vote. How secret can the vote be if it is being constantly accessed by a foreigner from a distant location? What is the guarantee that this foreigner will not grant further access to other unauthorized persons to commit all manner of mischiefs? But more important, Madam Chief Justice and the honorable members, is the complaint by Justice